Welcome to Law and Crime. I'm Terri Austin. We have a lot to cover in the next 2 hours, but right now, I want to take a look to a brand new trial starting this week out of Norfolk County, Massachusetts. Defendant Karen Reed is accused of killing her boyfriend, Boston police officer John O'Keefe, in January 2022. After a night of heavy drinking, prosecutors argue they read she backed her SUV into the victim and let him die in a snowbank outside his friend's house. On the other hand, Reed's defense team believes she's being framed in a massive cover-up orchestrated by both witnesses and law enforcement. And keep in mind that a federal investigation concluded that the victim's injuries were not consistent with having been hit by a car. Reed faces charges of second-degree murder, vehicle manslaughter while intoxicated, and leaving the scene of a collision. If convicted, she faces life in prison. A final pretrial hearing took place Friday ahead of this week's jury selection, and the prosecution argued to redact the cause of death from the victim's death certificate. So let's hear how that went.
So, Your Honor, this is the Commonwealth's motion to preclude reference and redact the manner of death contained on the victim's death certificate. This is a routine motion the Commonwealth files in really respect to any case. Manner of death.
That's not persuasive, so go ahead.
No. I'm just, manner of death as elucidated in the motion is not something that is typically something that is permissible to be testified to from anybody to the jury, because that's sort of the question of liability ultimately that is left to their discretion as far as how they find the facts. But cause of death obviously is something that is a medical determination. Manner of death, as the court is well aware, is there are essentially 3 or 4 different selections, and they fall into different categories. They don't necessarily mean in the medical context what they might mean in the legal context. So for that just sort of simple differentiation of meaning between the two, manner of death is not something that the Commonwealth feels is appropriate for the court, for any witness to be testifying to as far as the jury is concerned, as that's a question for them ultimately to determine. For those reasons, the Commonwealth would ask that this motion be allowed.
Thank you, Your Honor. The medical examiner who completed the death certificate in this case concluded that the manner of death was undetermined. The Commonwealth now seeks to have that portion of the death certificate redacted because it is quite clearly exculpatory. All of the cases cited by the Commonwealth deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death as a homicide, because it violates a defendant's right to due process and a fair trial under the 5th, 16th, and 14th Amendments to the United States Constitutions. None of the cases cited by the Commonwealth stand for the proposition that a medical examiner's determination that the manner of death is undetermined should be redacted. In fact, the Commonwealth cites Commonwealth versus Ellis at 373 Mass 1, it's a 1977 case, for the proposition that excluding the word undetermined is the better and safer course. But that's a misstatement of the law, and I would urge the court to read the Supreme Judicial Court's opinion in that case. What it actually says is this, quote, "Nothing contained in the record of a death which has reference to the question of liability for causing death shall be admissible in evidence. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that list of words that the Supreme Judicial Court warned about is the word undetermined." That is what the Commonwealth seeks to have redacted here. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred, and their own medical examiner has opined that she was unable to make that determination. That finding is relevant, it's exculpatory, and there's no authority that supports its redaction.
All right, those are interesting arguments. Joining us to break this down, we have criminal defense attorney Sky Lazaro and civil rights attorney Adante Pointer. Sky, I'm going to start with you. Now, the judge took the ruling under advisement, but if you were in the judge's shoes, how would you rule on this issue?
It's an interesting issue where it's undetermined instead of a more prejudicial word such as homicide or suicide, things like that. I think undetermined is less hurtful or less prejudicial, but it's hard to say. what she'll do in it. It is notable, I think, that those words are specifically, or that word is excluded from the Supreme Court ruling.
Yeah, I think it's interesting. I think the prosecution just wants it to say nothing, basically, because undetermined might rule in favor of the defense. All right, Adante, I'm going to get back to you on the other side, but first, let's take a look at portions of another argument involving a third-party culprit defense.
The investigators in this case, Your Honor, including Michael Proctor, kept Colin Albert's name completely out of the police report. When this case began, I had no idea who Colin Albert was. I received a tip right from the jump that Brian Albert and his nephew had beaten up John O'Keefe. I didn't even know Brian Albert had a nephew at that time. But after receiving the tip, I learned of the conflict that Colin Albert had with John O'Keefe, so I sent a letter to Mr. Lally, I believe by certified mail. I knew that the DA's office was planning to present evidence or witnesses to a grand jury, and at that early juncture, before anybody had asked them to indict, I notified the DA of 3 potential suspects, the ones that I'm talking about now: Brian Higgins, Brian Albert, and Colin Albert. After he received that letter at our next court appearance, I'm sure Mr. Lally can confirm this, he acknowledged that both Brian Albert and Brian Higgins would be testifying or had testified before the grand jury, but he questioned why I included Colin Albert in my letter. He told me at the time that he had no evidence that Colin Albert was there that night. However, after receiving my letter, lo and behold, multiple witnesses testified that Colin Albert was at 34 Fairview the night of January 28th to 29th. And now the DA will argue, I'm sure, at trial, that he left before John O'Keefe arrived. We don't find their evidence compelling. We don't accept it. We are not required to accept their theory of the case. We're entitled to present a defense. His presence at 34 Fairview gave him the opportunity, along with the motive, to harm John O'Keefe. With regard to Brian Albert, Your Honor, this is a well-connected, well-known, powerful family in the town of Canton, Massachusetts. Brian Albert was present at that home when Colin Albert was there. Colin Albert is a member of the Albert family. He's nephew of Brian Albert. We have evidence that Brian Albert had expressed hostility toward John O'Keefe as well. And we know that he initiated a phone call with Brian Higgins at 2:22 in the morning. He reached out to Brian Higgins.
First, again, what the case law requires is evidence and not just mere speculation, or saying that you have evidence is not actually evidence. I do find it somewhat interesting that Mr. Yannetti wrote apparently 4.5 pages of notes, but didn't have time to write a motion to admit the evidence that he claims that he has. He references in regard to third-party culprit, Dr. Sheridan, who indicated that the injuries are consistent with the fight. He's the same doctor who indicated that the injuries on Mr. O'Keefe's arm were consistent with the dog bite, which was then refuted by the DNA findings from UC Davis, as well as the fact that the injuries are only on one side of the arm. And last time I checked, dogs have teeth on the top and the bottom, and there's no injuries to the bottom of Mr. O'Keefe's arm. Furthermore, the counsel references the federal grand jury materials, in which I would say, as has been done numerous times previously, is severely mischaracterized as to what they actually contain. And it's not a crash reconstruction as it's been alleged here before, it's a biomechanical engineer. And essentially what they did was take painstaking lengths to go to determine that the defendant's vehicle did not strike Mr. O'Keefe in the back of the head, which is simply something that no one has ever said, intimated at any point ever.
All right, great arguments on both sides. I still have Sky and Adante. Adante, this one is for you. The defense presented 3 potential culprits for their defense of the case, and they think they have the right and sufficient evidence to actually present this theory to the jury. What do you think the judge should do here?
I think the judge has to let it in. You know, if you have evidence exculpatory evidence that you think that shows the jury and proves up that you're not the one that's responsible for this death, then I think you should be entitled to present that evidence to the jury. And frankly, that's what a defense attorney is supposed to do. Muddy the water, point the jury in the direction of the culprit, or at least show that your client is not the one and that there's not sufficient evidence beyond a reasonable doubt to hold them accountable. The defense is doing a good job.
Exactly. And Sky, when you have someone else to point the finger to, it's better than just saying, well, the prosecution didn't prove its case. And do you think the judge is actually going to allow it in?
I think they have to. I think in a case like this where they're actually presenting, sufficient argument that, isn't just speculative, it has to come in. Otherwise, there's a good chance that, this case may come back on appeal.
Yeah, I agree. I think the judge has to let it in. And when you have a case where you can actually point to someone else, it's really going to help the defense. All right, thank you both for weighing in. Stick with us on Law&Crime. We're going to continue to cover this very high-profile case out of Massachusetts from gavel to gavel. In the meantime, we have to take a quick break, but stay with us. We'll be right back.